Thank you for that very nice introduction, and I thought it was very kind of Professor Johnson, not to mention my wholly undistinguished performance in his first year property law class. But I will say in my defense that at the time I didn't think that property law was relevant to what I intended to do. When I became a legal aid lawyer and spent several years as a landlord-tenant lawyer, I badly wished I'd paid more attention. So I caution all of you that I felt this way about corporations too, and now I do almost nothing but sue corporations. So pay attention. Things you don't think may be important will turn out to be critical. The Southern Poverty Law Center, where I work, is a civil rights organization that was founded in 1971 in Montgomery, Alabama, the heart of the civil rights movement, the place where I now live. Our goal at SPLC is to work ourselves out of a job, to have a society that treats all with fundamental fairness and dignity. And our work is far from done. The civil rights movement in the United States is not over. It's alive and kicking. And the good news for those of you who have read accounts of the heroic actions and the courage of the folks who participated in that movement and long to have been a part, is that it is still possible for all of you, as lawyers and as human beings, to play a part. It is more than possible. As a lawyer, I would suggest it is essential. The civil rights movement of today is broad and rich. It involves the struggle for gay and lesbian rights, rights of children, the disabled, African American women, all people of color, the rights of immigrants. And it's important to see those struggles in their context as part of the same struggle. Dr. King has said that the moral arc of the universe is long, but it bends toward justice. As a civil rights practitioner, the most optimistic thing I can say is that some days I do believe that. At the Southern Poverty Law Center, I work with dozens of law students and young lawyers who come to the Deep South to study the civil rights movement. Many visit the great civil rights museums and historic sites of the South, the 16th Street Baptist Church in Birmingham, the Edmund Pettus Bridge in Selma. Southern Poverty Law Center has a beautiful museum, the Civil Rights Memorial Center, that people visit. And students long to have been a part of that movement. And sometimes they join that movement, and they are a part of that movement. The issues that Dr. King spoke about, race, injustice, poverty, are at the heart of the work that we do at SPLC and the work of many fine organizations. We work with private law firms across the country who do cases with us pro bono and who also embrace these great causes. It's always dangerous and sometimes silly to speculate what Dr. King would have thought about a particular issue. You hear his relatives speaking about how Dr. King would have thought about a particular issue, and it reminds me of the time that I spent in Charlottesville and the folks who used to speculate about what Thomas Jefferson would have thought. And the moment of complete silliness for me was when I was at a city council meeting and people actually argued when we were here in Charlottesville moving from a large trash bin system to a trash bag with sticker system, that Thomas Jefferson would have preferred one of these systems over the other. But looking out over the building where I work in Montgomery, Alabama, every day to see the Dexter Avenue Church where Dr. King preached, less than a block away, it's hard not to think about the lessons that he taught us. Just a few years ago, we celebrated the 50th anniversary of the Montgomery bus boycott, in my view, one of the truly great things that humankind has ever done. Tens of thousands of people walking for more than a year to bring one form of vicious segregation to its knees. And in the Montgomery, we have the honor of living among many of the heroes who took part in that endeavor. There's a great tour you can take at the Dexter Parsonage, at the Dexter Avenue Parsonage, where you can see the place that Dr. King spent so much of his Alabama time. It's worth coming to Montgomery for just that tour, to hear the incredible Shirley Cherry, who runs the tour, tell the stories of Dr. King and his time in that parsonage. She talks about the difficult times that Dr. King faced during the bus boycott, when he received death threats on many occasions, and something that she talks about as his famous kitchen incident. And here's how she tells the story. As Dr. King's wife, Coretta, and his 10-week-old daughter, Yolanda, slept in the master bedroom nearby, he received a phone call that said something like, "We're tired of your mess. If you aren't out of town in 3 days, we're going to blow your house up and blow your brains out." Dr. King went into the kitchen, made himself a cup of coffee, and buried his face in his hands. He began to pray out loud. He said, "Lord, I am down here trying to do what's right, but I must confess that I am losing my courage." And Dr. King explained what happened next. He said, "I could hear an inner voice saying to me, 'Martin Luther, you stand up for the truth. Stand up for justice. Stand up for righteousness.'" And he said his fears ceased. Several days later, around 9 o'clock, a bomb exploded in his house, on the front steps of that house. No one was inside and no one was hurt. I want to come back in just a little while to that moment in Dr. King's kitchen, and I think what it means for all of us today, at least according to Shirley Cherry. But I'll talk just a little bit about the state of Alabama, because I live there and it's a rich treasure trove of interesting history and current issues. This year is the 50th anniversary of so many incredible events. The Children's March in Birmingham, where children faced Bull Connors, firehouses, and dogs. George Wash's stand in the courthouse door. The bombing of the 16th Street Baptist Church, where 4 little girls were killed. Birmingham is no longer the most segregated city in the United States, and it is no longer primarily controlled by white folks. But the African-American children of that city continue to face brutality. The overwhelmingly African-American school system, I think the population is something like 98% African-American, routinely are exposed to the use of mace as a disciplinary tactic in their schools. The Southern Poverty Law Center represents kids in a class action challenging that disciplinary practices. The schools there are so pathetically underfunded that high school kids are not issued textbooks in many of their classes. And I'll get back in just a moment to funding of schools in Alabama. But when the children and the grandchildren of those brave kids who marched in 1963 are subjected to violence and brutality in our schools, how far can we say that we have come? Looking at the funding of schools in Alabama, I would say to those of you who think that the vestiges of slavery are things that are long past, look at the Alabama system of funding education and the way those schools are funded. I'll tell you just a little bit about one of the most interesting district court decisions I've read in a long time. And I have to tell you a little bit because it's 854 pages, but it's very interesting. It was not one of our cases. It's a case called Lynch versus Alabama. And there the plaintiffs challenged the Alabama educational funding system, which was established pursuant to the 1901 Constitution of Alabama, which is our current Constitution, and which is an expressly, overtly racist document. That Constitution places severe limits on property taxes and taxes to fund education, specifically for the purpose of denying education to African American children and to ensure that the plantation owners of the Black Belt, the area of Alabama known for the black soil, but coincidentally where the largest percentage of African Americans live, to ensure that they would have workers and that white people didn't have to pay for African American kids to go to school. In the 1970s, amendments further limited property tax options for local governments. They allowed the use of what was called the current use valuation for farm and timber property. This valuation, which doesn't apply to very small farms, was designed to benefit the plantation owners, yields very low revenues. And as a result of this system, it is impossible for rural counties to generate any significant funds for their schools. Alabama's property tax rates are the lowest in the nation. And as one of the lawyers who brought that case has said, these big black belt landowners used white hostility to black education in 1875 and in 1901, and again in 1971 and 1978 when George Wallace was governor, to undermine property value assessments and restrict the millage rates. I highly recommend this opinion, which is interesting in many ways, but also because the plaintiffs actually lost, but which lays out in just utterly compelling reading the racial history of the South and the way the decisions that were made hundreds of years ago echo today and doom children to sorry schools and a true lack of opportunity. And so I ask you too, when the great-great-great-great-grandchildren of those who were denied an education because of a system of racial segregation, still can't get anything close to an adequate education, and where almost all white kids opt out of the public school system and send their kids to private schools, how far can we say that we have come? Now, I have devoted most of my career, many years of my career, to fighting for justice for immigrants, and it has been an honor and a privilege to do that work. I know that not everyone agrees with my position or the position of the Southern Poverty Law Center about the appropriate level of immigration for the nation or the compelling need for comprehensive immigration reform. And I think that good people can disagree about these things. But I also know that much of the public discourse about immigrants is deeply infected by racial prejudice. And I want to talk a little bit about that in the context of the law that Professor Johnson referred to, HB 56, which was passed in 2011. And it was widely touted as the most extreme anti-immigrant law in the nation. Now, usually I don't have to try too hard to convince people outside of Alabama that Alabama has issues with racial prejudice. But I would suggest that what I'm about to tell you is not limited to Alabama, because these laws have been drafted very clearly as part of a national agenda. HB 56, as passed, had 30 provisions. A number of them have been now enjoined by either the district court or the Court of Appeals. But the provisions weren't designed to affect, according to its proponents, every aspect of an immigrant's life, from their ability to enter into contracts, to rent houses, to obtain any kind of government benefits, or enter into business transactions with the state. It included a provision that made it a crime to transport, shelter undocumented immigrants, thereby criminalizing religious and charitable organizations. It included a section that prohibited many legal immigrants from attending public college or university in the state. And it included a section, a new and novel section that hadn't been passed anywhere else, which required school officials to verify the status not only of children but of their parents. Section 28, which is the section I just referred to, the school section, went into effect for approximately 2 weeks before it was enjoined by the United States Court of Appeals for the 11th Circuit. And although we're pleased that it has been enjoined, great damage had already been done. The Latino children of the state of Alabama had heard the message loud and clear that they were not wanted in the state. In fact, HB 56 devastated the immigrant community in Alabama. It would be hard for me to overstate the human tragedy that was unleashed upon Alabama by this law. Under the provisions of the law that did go into effect, undocumented persons were unable to interact with the government in any way and for any purpose. It turned a significant class of people effectively into legal non-persons, subjecting them to a kind of legal exile. It destroyed lives, ripped apart families, devastated communities, and hurt our economy. After HB 56 went into effect, SPLC and the other civil rights groups representing plaintiffs started a telephone hotline to field calls about the law. The first weekend received over 1,000 phone calls. The breadth of the problems that were created both directly and indirectly by the law was breathtaking. Just a small sample of the kinds of stories that we heard on our hotline as people called us. A mother in northern Alabama called us to say that she could not attend a book fair at her daughter's school because she didn't have an Alabama state ID or driver's license. A father called us to report that his United States citizen daughter came home weeping from school after other students told her to go back to Mexico, a country she had never visited. A judge advised a lawyer that the obligation that she had to report her own client to ICE superseded her obligations to keep privileges and communications. And the same judge stated that he might have to report to ICE any person who asked for an interpreter, as such a request would be a red flag. Latino workers on a construction job site called us to report that they'd been threatened by men with guns who told them to go back to Mexico and threatened to kill them if they were there the following day. They declined to report the crime because of fears that what would happen to them if they went to the police. A clerk at a store in Bessemer told a Latino man who was lawfully present in the United States, who was from Ohio, that he could not make a purchase because he did not have an Alabama state-issued identification or driver's license. A victim of domestic violence went to court to obtain a protective order. The clerk told her that she would be reported to immigration if she proceeded. By the second Wednesday after the law went into effect, 5,554 Latino students were absent from schools across Alabama. This represented more than 15% of the total Latino population of school kids. The overwhelming majority of Latino kids in Alabama schools are United States citizens. In several counties, the Water Authority provided notices to Latino customers that their services would be shut off if they didn't provide proof of legal immigration status. Numerous probate offices, including the Montgomery County Probate Office, published notices indicating that they wouldn't provide services to anyone without proof of immigration status, which meant that many immigrants could not obtain birth or death certificates. An apartment complex manager in Hoover told residents they couldn't renew their leases without proof of legal status. A worker called to say that an employer refused to pay him, citing HB 56, and stated that the worker had no rights under the law. A mother called us to say that the local office of the Department of Human Resources told her that her United States citizen children could not obtain food stamps without the social worker turning the family over to ICE. Instead of receiving food stamps, the family went into hiding. A husband called us to report that his wife, 9 months pregnant, was too afraid to go to a hospital in Alabama to give birth. A Latino man was arrested and detained. While in jail, he was told that he could not use the telephone to call his attorney because the use of the phone would be a business transaction, which was prohibited by HB 56. Now, HB 56 was drafted, at least in part, by a man named Chris Kobach, who is with a group called the Immigration Reform Legal Institute, EARLY. EARLY is the legal arm of the Federation for American Immigration Reform, a group that is listed by the Southern Poverty Law Center as a hate group. Why do we list FAIR as a hate group? Well, we have a whole long publication about this with a whole lot of detail, but I'll give you a brief summary of that. FAIR has been designated as a hate group because, among other reasons, it accepted $1.2 million from the Pioneer Fund, a group that was founded to promote the genes of white colonials and that funds studies of race, intelligence, and genetics. FAIR has also hired as key officials men who also joined white supremacist groups. It has board members that regularly write for white supremacist publications. It promotes racist conspiracies about Latinos and has produced television programming featuring white nationalists. Dan Stein, its director, has expressed anger at the Immigration and Nationality Act of 1965, which sought to end the longstanding and racist system of quotas. President Lyndon Johnson, in signing that act, celebrated the demise of that old racist law, saying that it will never again shadow the gate to the American nation with prejudice. Dan Stein didn't see it that way. The act, he said, was a key mistake in American foreign policy by people who sought to retaliate against Anglo-Saxon dominance and create chaos. The Alabama law, then, is part of a national nativist agenda, but its effects played out in the state of Alabama with its own sorry history of race relations. In Alabama, the law was sponsored by a gentleman named Scott Beeson, state senator, who urged his fellow legislators to empty the clip and do what needs to be done about illegal immigrants. Representative Mickey Hammond, the House sponsor, said that he intended to, quote, attack every aspect of an illegal immigrant's life. SPLC, along with a number of other civil rights groups, has been involved in a number of pieces of litigation challenging the law. We filed a comprehensive facial challenge to the law, and we filed a number of as-applied challenges, including one that challenged Section 30, which is the business transaction provision, as it applied to owners of mobile homes. Alabama requires owners of mobile homes to register their home each year and get a decal. It is a crime, it is a misdemeanor, not to do so. But Section 30 made it a felony to attempt to register their homes. So in 2012, we filed a lawsuit to challenge that provision under the Fair Housing Act. We alleged that the law was motivated by deliberate racial prejudice. And I'll just share with you a little bit of what Judge Myron Thompson, in my view, one of the nation's great federal district court judges, had to say in granting our preliminary injunction. I love this decision so much. This decision is only 108 pages, so I recommend it to you. I could easily imagine giving a speech where all I do is try to read that opinion really fast because it really is a kind of a great document. And here's what Judge Thompson wrote just in brief. He wrote, "The court's concern is the fact that in their statements about HB 56, Alabama legislators often spoke about illegal immigrants and Latinos as the same thing in the same breath. The court must be sensitive to the use in the legislative debate of illegal immigrant as a code for Latino, with the result that, while addressing illegal immigrants was the target, discriminating against Latinos was the target as well. This use is dramatically reflected in how HB 56 drafter Mickey Hammond conflated race and immigration status. After a reporter inquired about Hammond's oft-repeated comment that Alabama has the fastest growing illegal immigrant population in the country and asked for evidence supporting that claim, Hammond sent the journalist a newspaper article that said that Alabama's Latino population had the second largest percentage growth between 2000 and 2010 and had nothing whatsoever to say about illegal immigration. Similarly, Representative Kerry Rich's opening statement to the legislature demonstrates the numerous ways in which legislators frequently conflated illegal immigration and Latinos in discussing the ills to be remedied by the law. Representative Rich began his testimony as follows. "I want to say to my colleagues here in the House that I realize completely that God loves Hispanics, just as much as he loves me, anybody in this chamber, and I don't question that. I don't question that one second. I like Hispanic people. Most of the Hispanic people are hard workers. Most of them have good family values. Most of them are good Christian church-going people. The ones I have a problem with are the ones that come here and create social and economic problems, and those problems are rampant in our area. And I want to make clear what happens in our area. Illegals come here and they have children just as soon as they can. That's what I'm talking about. They have children just as soon as they can, and then they start them in school." Judge Thompson went on to write that there was evidence that the legislative debate was laced with derogatory comments about Latinos. For example, Representative Rogers made comments that reflected stereotypes, the judge wrote, about Mexicans and drew explicit distinctions along the lines of race and national origin. Rogers argued that HB 56 was needed to punish employers. He says, "Now, some of these people come up here to Hoover and Homeland, which are a couple suburbs of Birmingham, and I saw about 30 of them get out of a car one day. I say, guys, it was a circus. They kept coming and getting out and getting out. But the part of it is that if we stop the employer from employing them, they won't come. I've gotten calls from Hispanics, but the killing part about it is, I'll tell you what happened. I know for a fact you won't believe that. When they get a chance to be legal, you know what they put on their driver's license? White. They put white down there." And I'm getting to the end of this, but along the same lines, Representative Thomas Jackson, who I must say voted against the law, commented that getting rid of illegal immigrants might be counterproductive because immigrants keep this nation functioning. And he said, "I'm talking about the people I saw when I went to visit the chicken house. There were 4-foot Mexicans in there catching them chickens." To be sure, the court concluded there are many other examples in the record that provide support for the inference that Latinos were the targets of this law. There were discussions of the over-representation of Latinos in certain localities in the state. and the assumption that those Latinos were undocumented. And the judge concluded by saying, there's simply no way to tell by looking at an individual what their immigration status is. And the evidence of what those legislators knew or purport to know, that these Latinos are unlawfully here, is nothing more than speculation. Nonetheless, when confronted with a similar absence of evidence, the same legislators assumed that other groups of people were legal. Thus, the combination of a lack of evidence and the assumption of unlawfulness applied to Latinos that is not applied to other groups supports an inference of racial discrimination. At SBLC, we have tried to take the hate out of the debate, and we have said repeatedly that we should have an open and fair debate about immigration. It's going on this week. But when our debate is dominated by people with racist ties, and when our legislators feel comfortable making these kinds of disparaging comments in public about a group of people, again, how far can we say that we have come? I mentioned early on that the civil rights movement today is broad and rich, and it does include the fights for the folks that Dr. King cared so deeply about, the poor. As has often been noted, Dr. King was in Memphis the day he was killed to support the sanitation workers' strike for better wages as part of his Poor People's Campaign. But I'm sorry that I think our nation has given up largely on the fight against poverty. We seem instead to have embraced a fight against poor people. Indeed, we have largely pathologized poverty. People are poor because they are bad. Their culture is sick, they don't want to work, or so it goes. I personally am of the opinion that poor people are poor because they don't have a lot of money. The people I know who work the hardest are the poorest people I know, the poorest people in the nation. And here too, much of that is in fact tied back to race. Just to give one example, the poorest workers in our nation are agricultural workers, people who put food on our table. There are 3 million farm workers in the United States, earning an average of about $15,000 a year, according to the federal government, a figure which is, in my view, wildly inflated by the fact that it includes supervisory crew leaders along with the actual field workers. Women workers earn an average of $11,000 a year. And for that astounding sum, they suffer some of the most grueling work conditions possible: exposure to dangerous chemicals, work in 100-degree-plus weather, back-breaking physical labor. Women are routinely denied bathroom breaks on the job. They experience rampant sexual violence in the workplace. In 2010, we published a report about women workers who put food on our table that we titled "Injustice on Our Plates." Every woman we interviewed told us that sexual violence was a serious problem in her workplace. And why is it that these workers are so poor? Some of that answer is absolutely historical. Farm workers are exempt from much of the labor protection laws that apply to other workers. For decades, they were exempt from the minimum wage law. They're currently exempt from overtime protections. Why? Why these exemptions? This was an explicit product of Roosevelt's compromise with white Southern farmers. This was a product of the New Deal compromise, where Southern legislators would not agree to pass these reforms unless their black field hands were going to be exempt. And I'd argue that there's no impetus to change these laws now, because the people who do this work still are people of color. The overwhelming majority of farm workers in our nation are no longer African American, they are Latino. And no one is talking about making life better for these workers. Farm workers aren't covered by the workers' compensation laws in many states, certainly in all states in the South. Child labor laws are riddled with exemptions for farm workers. In some states, farm worker kids are exempt from even having to attend compulsory education. State health and safety laws in most states in the South exclude farm workers. Farm workers are not covered by the National Labor Relations Act, which give workers the right to organize and improve their working conditions. In my view, it is impossible to avoid the conclusion that these exclusions are related to race. But I don't want to talk only about dismal things and the abuses that workers suffer. We see a lot of abuses in the work that we do. But I do want to finish with something hopeful, because I think there's a lot of hope. One example I can point to is I have been so inspired and thrilled to see the progress that has been made in the fight for lesbian and gay rights in the time that I have been a lawyer. I remember a decade ago or so saying to lawyers who were representing lesbian and gay folks fighting for marriage equality that I thought that their legal fight was sort of misguided, that why didn't they focus on something more easily attainable like non-discrimination in employment? And people said, well, you know, this is our strategy, we want it all, we're fighting for marriage equality. And I will say I was completely and utterly wrong. And it's been a beautiful thing to watch in such a short time, such a dramatic change in our nation. And I have seen from time to time moments in my job and in my work that look an awful lot like justice. Over and over again, I have seen men and women with very much to lose stand up for their rights and fight for those rights. My clients have been, I think, extraordinary people. I've listened to hundreds, thousands of stories over the course of my career. I've defended hundreds of clients who have sat through deposition and told their stories. In doing so, I've been struck by the similarities that workers express in answering one question that defendants' lawyers seem to always want to ask, which is, what do you hope to get out of this case? And almost all of these workers, to a word, have said, justice for the other workers so that no one else is treated this way. Not one of them that I can recall said money. And I believe that each of those clients was telling the truth, that they were deeply concerned for their coworkers and wanted the situation to be better. It is a great honor to represent people who truly believe in the idea of justice for all. From time to time, I have been interviewed about the work that I do, and I have been asked a question, why is it that I have chosen to sacrifice myself by doing this kind of work? And I know, and I guess that many of you know, that this is a dumb question. It's a flawed question, because it is not a sacrifice to do the kind of work that gives your life meaning and purpose. I look around at the lawyers that I know who are doing other kinds of work, and lots of them are not completely fulfilled and satisfied, and I do feel lucky. I look at my clients who perform grueling and dangerous work for little money, and I know that I am lucky. Low-wage immigrants generally do not have powerful political advocates, and by definition, they themselves cannot vote. They can't. In that context, the decision to stand up for their rights and go to court is an extraordinary and selfless choice. My clients have not gotten rich from the cases they've brought. Generally, they've simply received the money they were entitled to all along. But they have stood up for something more important than that, the right to be taken seriously as a human being and the right to be treated with dignity. And so now, just briefly, I want to come back to that moment in Dr. King's kitchen and what Shirley Cherry had to say about that. What she says is that moment holds significance for all of us here today. And what she says on this tour that all of you need to go on very, very soon is that people need to keep in mind that Dr. King didn't ride buses. He never had to ride buses. He didn't come from that kind of background, but he cared about the people who did, for people who were less well off. And what happened that night in that kitchen, she said, was a lesson for all of us, a lesson in commitment and obedience. And so here is my pitch to you. You are powerful people with the capacity to do much, for ill or good. I look back to my own experience as a law student in this fine institution, and I realized that I didn't fully appreciate that. I didn't appreciate that some of the people around me would be federal court judges, would be state legislators, would be cabinet level, presidential cabinet members. They would run giant law firms. They would decide which cases to take pro bono. They would lead society and make important decisions that would dramatically affect people's lives. And so will all of you. And so I will end with this plea that you all decide to participate in today's civil rights movement in whatever way speaks to you. There's so many ways that you can be part of this movement. You can find work that allows you to do it every day. If you work for a private law firm, there's so many pro bono opportunities that would allow you to be a part of that. You can be an activist. You can choose, if you like, to sit down on the floor of the Alabama legislature and get yourself arrested, as some of my colleagues and I did in the last year in protest of some of our laws. But I hope for all of you that you're as lucky as I am in finding work that provides such great meaning and happiness in your life. And I implore you to consider at least a career in public interest law, not because you will make the world a better place, although perhaps you will, but because being a part, however small, in pushing the moral arc of the universe a tiny bit closer to justice is an honor and a privilege. Thank you.